Give me a second to settle this screen. Yeah, at least this much so that I can see that it is working well. Okay, Bacha, in the earlier class, when we started with the concept of contract, so as per section 10 essentials, हमने एक essential discuss किया था, that was capacity of parties, right? And we have discussed that the person who is entering into the contract must be competent to contract. When we talk about the competency, so what does it mean within the meaning of Indian Contract Act? What the law says that who is going to be considered as eligible or capable of entering into the contract. So if we talk about the competency of contract as per the Indian Contract Act, so section 10 says that every person, every contract should be supported by a lawful consideration with a lawful object which has not been expressly declared void, and the essential element says that the party must be competent for entering into the contract. So this, until unless all the essentials of section 10 are present, it cannot become a contract, and if it is not a contract, it cannot be enforced by law. तो जो हमारी रेमेडीज आती हैं इंडियन कॉन्ट्रैक्ट एक्ट में वो फिर एप्लीकेबल नहीं होंगी. तो इस पर्टिकुलर सिचुएशन में competency of party becomes one of the essential element for the formation of the contract. And if we talk about the section 11, so section 11 defines the competency of the contract, and section 11 says that a person who is of the age of majority to the law to which he is subject, this we are going to discuss in detail, to the law which he is subject, a person who is of sound mind, and a person who does not fall in any kind of disqualification. This should be not disqualified by law. So these three requirements says that a person who is of the age of majority to the law which he is subject, the person who is of sound mind, and the person who is not disqualified by law is going to be considered competent to contract. So it means that here the qualification or competency is dependent upon the age, soundness of mind, that is the he is able to make the rational judgment, he is able to understand the circumstances, terms of the contract, whether these are beneficial for him or not. And here, if there are certain disqualification or restrictions, so the person is not covered by those disqualification and restrictions, then in that case, the person will be considered as competent to contract. So, in other words, if we say that who is competent to contract, a person who is not competent to contract, who is a minor, who is of unsound mind, and who is disqualified by law under certain criteria which we are going to discuss, is considered as incompetent or not qualified for formation of contract. What does it mean? It means that if there is any situation or promise which is being entered into by any of these parties, this is not a contract, not enforceable. Up till now, is it clear? The definition of competency of parties? Yes, you can write in the chat box as well.
Clear, ma'am.
Okay. Now we move further that what is the reason or how we understand that if a contract is entered into by minor, what will be the situation? What will are there any exceptions to the rule, or who is regarded as minor? What will be the nature of minors agreements? What will be the remedies available to the minor or to the party in the different situation? What will be the position of if the particular contract has been entered into by a person of unsound mind, whether the person is of unsound mind permanently or temporarily. So, will it make any difference if a person is under the effect of any, intoxicated item and that time he has entered into contract, because that unsoundness of mind is temporary. So, what will be the legal point of view or legal standing in that situation? And what are the situations or circumstances where the person is considered as disqualified by law? So, all these three aspects we are going to cover in this chapter. So, starting with the pre-concept of minor. Now, my dear friends, when we say minor, we say two conditions, that who attains or who is considered as minor, and we use the word to the law to which he is subject, मीन्स कि किस लॉ के अंदर वो आपका कवर होता है. सो इन दी इफ वी टॉक अबाउट दी माइनस एक्ट, सो वी हैव द इंडियन मेजोरिटी एक्ट which is Indian Majority Act 1875. So, as per Indian Majority Act 1875, जो माइनर की एज है वो आपकी 18/21 ईयर्स है. 18 years is in the normal course of circumstances and 21 years in the case of कि जहाँ पे आपका guardian are appointed for the minors, or there is the property is under the preview of court of wards act. So वहाँ पर आपका 21 years हो जाता है. Otherwise, as per Indian Majority Act 1875, it is 21 years. And this particular Guardian and Wards Act 1890 is being covered, और the where the court of wards के अंदर आपकी प्रॉपर्टी है वो आपकी उस सुपरविजन में है. So in those situations there is 21 years. But when we talk about the recent situation, so in the parliament under section in the year Care and Protection of Children Act 2015 में सारे आपके माइनस के लिए जो एज है वो लोकसभा में पास करके 18 इयर्स कर दी थी. सॉरी, दिस इज नॉट 2015, दिस इज द इंडियन मेजोरिटी एक्ट अमेंडमेंट एक्ट 1999. इंडियन मेजोरिटी एक्ट 1999 में सारे सिचुएशन में जो माइनस की एज है वो बिलो 18 इयर्स फिक्स कर दी थी. आफ्टर दैट इन 2015 when there was a case law, so in that situation the as per the court of justice juvenile justice act it has been held कि माइनर्स की जो एज है वो आपके 16 to 18 years के अंदर एडल्ट्स कंसिडर कर सकते हैं, depending upon the heinous offenses and the situation. So, in that case, even the particular person is considered as major at the age of 16 years. So, in those circumstances, that's why we say that the minor age would differ from to the law which he is subject. So, as per Indian Majority Act, it is 1875, and as per the Guardian and Courts of Wards of Property Act, this is 21 years. Then, as per the Indian Majority Amendment Act, it has been selected as 18 years in all the cases, and in 2015, under Juvenile Justice Act, it has been declared that the age of the minor major will be the persons between the age of 16 and 18 can be considered as a major if there is any heinous offense or any circumstances. As such, if, all of us are very much familiar with the Nirbhaya case and all
मैम,
these. हाँ जी बेटा.
यस मैम, आई वाज अबाउट टू टॉक अबाउट दैट ओनली.
हाँ जी.
मैम, उस टाइम पे जो माइनर था मैम, उसको तो जुवेनाइल जस्टिस एक्ट के अंदर ट्राई किया गया था. सो मैम,
वो
अगर जैसे मुझे अभी पता चला कि 2015 में अमेंडमेंट आ गई थी कि डिपेंडिंग अपॉन द हीनियसनेस ऑफ द क्राइम.
Hmm.
16 से 18 को हम मेजर की
Hmm.
तरह ट्राई कर सकते हैं, तो
Yes.
2020 में मैम फिर उसको हैंग क्यों नहीं किया गया साथ में?
Because this is the, it is, he has been punished, he has not been, spared, but in that situation the law or the court decides that which kind of punishment is to be covered. But in that situation, other, if it would have not been covered as a minor, we'll discuss in a coming section, that if we talk about any situation if the minor, so minor cannot be held liable, personally liable, or minor cannot be, punished. So that situation was there, but again, because of the circumstances, he has been considered and punishment was there. He has not been released.
ऑलराइट मैम।
Right, so this is again we are talking about that to law which is subject means that the particular circumstances of the case, court decision, and the other things matters. ठीक है बेटा?
यस मैम।
Right. So now let's move further. So first thing is that the definition of minor is clear to all of you. Now next is the object, that how the minors are being taken care by law. So when we talk about the Indian Contract Act, in Indian Contract Act we are talking about the business transactions. We are talking about the your promises on the basis of the relationship, business relationships, etc. So in this particular situation, there can be, if we talk about the contract with the minor, so our preview will be the ordinary mercantile act. So simple, your ordinary business transactions are going to be covered, and there can be certain kind of the land transactions or the property, etc., is being there. So if we talk about the position of the minors, so minors' position is that it is being said that the law protects the interest of the minors. The objective is that law protects the protection clock around the minors. Reason being that they consider minor as infants. Infants means that they can be misguided. They are not, capable enough to take the rational decision. Or the people, those who are more mature or experienced, so they can take the undue advantage of the minors. So to stop that undue advantage, to take care of the minors because they are not in a particular situation to enter into the transaction, or to understand which kind of agreements, etc., are there, whether these are going to be beneficial for them or not. So for that reason, law protects, and in that case, it is being clearly given that an agreement with the minor is void. Void means not enforceable by law, right? So in the earlier classes when we discuss about the types of the contract, so there we have discussed void agreement is one which is void ab initio. Void agreement is one which does not give rise to any of the legal obligation. Void agreement is one which does not create any kind of enforceability within the preview of law. Void means which does not provide any kind of remedies within the contract. So in that, from that aspect, in certain situation, this particular situation, that if there is an agreement with the minor, is going to be declared void. But there can be certain exceptions to the rule, wherein the parties can enter into the contract from the point of view, they can take the advantage of the other parties. So in that case, because the other party should not get affected, or the other party should not misguided, so in the certain circumstances it is going to be valid. अगर माइनर अपनी एज मिस रिप्रेजेंट कर देता है या मिस गाइड कर देता है दैट ही इज इन एज ऑफ मेजोरिटी एंड द अदर पर्सन इज एक्टिंग इन अ गुड फेथ, सो उस केस में किसी किसी सिचुएशंस के अंदर वो कॉन्ट्रैक्ट जो है वैलिड हो जाते हैं. बट स्टिल वी कैन नॉट हेल्ड द माइनर्स पर्सनली लायबल देयर. उनकी प्रॉपर्टी एंड द अदर पर्सन can be held liable for that. Minor cannot be held personally liable in that situation. और कुछ circumstances होते हैं where the parties have the right to set aside the contract in certain situation. So there the particular contract becomes voidable. So us we have to learn in nature of minors agreement कि agreement with the minor void कहाँ पे होगा, valid कहाँ पे होगा और voidable कहाँ पे होगा, कहाँ पे हम उसको partially enforce कर सकते हैं और कहाँ पे हम उसको partially set aside कर सकते हैं. So these things we are going to learn in the nature of minors agreement. So make sense? You able to get it up till now what we have discussed? Yes?
Yes, ma'am.
Yes, mom.
Okay. So now let's continue with the very first situation where we say an agreement with a minor is void. Void ab initio. जब हमने enforceability by law की बात करी थी तो उसमें हमने डिस्कस किया था agreement expressly declared void. तो उसमें हमने डिस्कस किया था कि जहां पर आपके कॉन्ट्रैक्ट के एसेंशियल एलिमेंट एनफोर्सेबिलिटी बाय लॉ वाले मिसिंग होंगे वहां पे आपका जो कॉन्ट्रैक्ट है दैट एग्रीमेंट कैन नॉट बी become a contract. That agreement cannot be enforced by court of law. So first, very first situation is that we know who the minor is. So we consider that minor as per the law to which he is subject, he is considered as minor. Second situation is that the nature of minor agreement is, it is said that agreement with minor is void ab initio. Right? Void ab initio. Void ab initio means absolutely void. And void, what does void means? Void means not
Not
enforceable
enforceable by law.
by law. Right? And ab initio means from very
Starting.
Beginning.
beginning, very beginning. It's not going to be enforceable at any stage. So that's why we say that when we discuss the meaning of void agreement and void contract, so we differentiated the two on the basis that this particular void contract is one which was enforceable by law at the beginning, but which ceases to be enforceable by law at a later stage due to change in circumstances. But when we use the word void agreement, the void agreement is void ab initio, which is not enforceable by law from the very beginning. So it is absolutely void, not enforceable by law, does not give rise to any legal obligation. Right? So this particular thing, the first situation or the first circumstances at the face of it, when we say an agreement with a minor, then an agreement with a minor is void ab initio and remains inoperative. You cannot, because we say if there is a contract, you can go to court of law, you can compel each other, you can ask each other to perform whatever has been promised. बट अगर वो अग्रीमेंट माइनर के साथ होगा तो आप उसको कंपेल नहीं कर सकते परफॉर्म करने के लिए. सो दिस प्रिव्यू और दिस पर्टिकुलर सिचुएशन इज गिवन विद इन द मीनिंग ऑफ लॉ इटसेल्फ. So when we say about this particular situation, there is a very important well known case of Mohiri Bibi versus Dharmodas Ghosh. Spelling is GH. I always get confused. GHOSH. Right? So this particular case law has been taken as the, we can say, the landmark case or the basis. There are other cases also we are going to discuss, but this particular case supports this particular point that an agreement with a minor is void ab initio. So in the earlier classes also we have discussed that how to write a particular case study. So there I told you earlier as well that whenever we start with the case, so we see the facts or the storyline of the case, which becomes the basis. Then we talk about the provisions to which a particular situation, circumstance is related, and the third one is the judgment of the case. So on these bases, the further cases or the similar situations are being handled. So if you get a similar kind of situation or point in your exam. So then you have to explain that point with the provision, and you have to support your answer with the supported case law. So now in this particular case, when we talk about the Mohri Bibi versus Dharmodas Ghosh case, so in this particular case, minor has borrowed some money. So we say the situation was that minor has borrowed some money, and in return, minor has mortgaged his property, right? So in that particular situation, because this was a deed by the minor, so minor went to court of law to set aside that mortgage property, because he was a minor and he could take the advantage. So he set aside he filed a case in the court of law and to set aside the mortgage, and the decision was in his favor, right? So it has been held that because the agreement was with the minor and the agreement is not enforceable by law, so this mortgage is inoperative. The other party does not have any right or any access to the particular property to claim the money borrowed. Now, the other party got disturbed. The other party has filed a case against minor to claim the money back, right? And in that situation, they also got a declaration signed from the minor that he is not minor, he is major. Are you getting the storyline or background of the case? माइनर ने लोन लिया किसी से और अपनी प्रॉपर्टी उसको साथ में मॉर्गेज कर दी टू गिव द सिक्योरिटी ऑफ द लोन. But later on, minor filed a case with the help of, along with his guardian, etc., to set aside the mortgage, and the mortgage has been declared as inoperative because the agreement was with the minor. Now the other party has got a declaration signed from the minor that he is not a minor, and they have asked for the claim of loan. It has been set aside. The decision was against them, and it has been held that an agreement with a minor is void ab initio. An agreement does not give right to legal obligation. It is inoperative. It is absolutely void. Is it void from the very beginning? So, if this particular point comes, or you have to explain this particular point, then in that case, this case law you have to consider, and you have to explain this particular case law, and this case law is of 1903, right? This is, I can write here. And if you by any chance can access these notes or Photoshop documents, so I can share these slides with you as well on the classroom. Or if you can take the screenshot simultaneously, I don't mind, right? So in the first point, we say an agreement with the minor is void ab initio. So in view of the case of Moiri Bibi versus Harmodas Ghosh case, it has been held that an agreement with the minor is void from the very beginning. It is inoperative because minor is not capable, minor is not competent to enter into the contract, right? Can we move further? Okay. Now, the next situation is that when we say that you must have got a query in your mind that if minor has taken the loan, so minor is not bound to return that loan, right? On that basis. So, what does it mean? Have you got this question in your mind?
I was about to ask this, ma'am.
Anji. So, in view of this inquisitiveness or question, the second situation comes which says that is doctrine of restitution does not apply against minor. राइट, तो पहले समझ लेते हैं कि डॉक्ट्रिन ऑफ रेस्टिट्यूशन क्या होता है. तो डॉक्ट्रिन ऑफ रेस्टिट्यूशन सेज दैट व्हेन अ पर्सन receives some cash benefit or any other thing under a contract, and when this contract is set aside, the party is bound to return or repay such benefit received by him under the contract, because पहले वो contract perform कर रहे थे, ठीक है. So that contract was to be performed. So if it is not performed, then in that case, as per law or as per the requirements of the quasi contractual obligation, that you cannot take undue advantage or benefit yourself at the expense of the other, you are bound to return that benefit, right? But in case of minor, law says doctrine of restitution does not apply against minor. कि अगर माइनर को उस कॉन्ट्रैक्ट के अंदर कोई भी बेनिफिट या मनी मिली है या और कोई भी डेट्रीमेंट और any other thing he has received, he is not bound to return. On the basis of there are two rules. One, we say agreement with minor is void, and second, that when we talk about doctrine of restitution, it applies in case of voidable contract, not in case of voidable agreements. So the on the basis of these two rules कि एक तो एग्रीमेंट विद अ माइनर वॉइड है, एनफोर्सेबल बाय लॉ नहीं है, तो उस बेसिस पे आपका डॉक्ट्रिन ऑफ रेस्टिट्यूशन अप्लाई नहीं होगा. इट इज वॉइड फ्रॉम द वेरी बिगनिंग, इट डज नॉट गिव राइज टू एनी ऑफ द legal obligation. So in even if the other person was aware of that he is a minor, he got a declaration signed that he is not a minor, then also the other party cannot claim the money back. Secondly, कि doctrine of restitution है as per law, it applies in case of the voidable contract. But there are certain exceptions to this particular rule. वो रूल क्या है कि दे बिकॉज वी से कि हमने कहा ना कि किसी किसी सिचुएशन में वो वैलिड हो सकता है, इट वुड डिपेंड अपॉन द सर्कमस्टांसेस. तो उस सिचुएशन के अंदर वी से दैट वेयर देयर इज अ रूल ऑफ स्पेसिफिक रिलीफ एक्ट, स्पेसिफिक रिलीफ एक्ट 1963. तो इसमें सेक्शन 33 ऑफ स्पेसिफिक रिलीफ एक्ट क्या कहता है कि किसी सर्कमस्टांसेस में जहां पे माइनर ने अपनी मिस रिप्रेजेंट करी एज, the other person has acted in good faith, the other person was not aware of that he is a minor. So in those cases, the court have the advantage or court can give the decision, and doctrine of restitution is applicable. It means that if the money, etc., has been received by the minor, and in that situation, the minor has misrepresented the age, the other party has acted in good faith and was not aware of that he is a minor, then in that particular case, the rule of section 33 of Specific Relief Act is applicable. So, in certain situation where the court has refused the doctrine of restitution, was Moiri Bibi versus Harmodas ghost case. There was a case of Khangul versus Lakha Singh. You can refer. इन केसेस के अंदर डॉक्ट्रिन ऑफ रेस्टिट्यूशन अलाउ नहीं किया गया था, बट इन सर्टेन सिचुएशन दिस हैज बीन allowed in the case law of Jagir Nath Singh versus Lalita Prasad. In this case, what happened? That minor has sold his house by misrepresenting his age for 50,000, and later on he wanted to set aside the contract on ground of minority. So in that case, the other person has received the money, has a right, and have got rupees 50,000 back, which has been taken by the minor. So in certain situation यहाँ पर डॉक्ट्रिन ऑफ रेस्टिट्यूशन जो है हमारा अलाउ नहीं हुआ था, right? So where it the even the other party could not recover the loan given to the minor, but in the case of Jagirnath versus Lalita Prasad. In this particular case, the doctrine of restitution was allowed. Doctrine of restitution was allowed. And on which basis it has been allowed? It has been allowed under Section 33 of Specific Relief Act. As per Indian Contract Act, as per the rule, we say an agreement with the minor is void ab initio, void from the very beginning. But in this particular situation where the minor has misrepresented the age, क्योंकि हमने फर्स्ट में ही डिस्कस किया कि दो ऑब्जेक्ट हैं. फर्स्ट तो है कि आपका माइनर जो है वो इनकॉम्पिटेंट है, नॉट केपेबल ऑफ एंटरिंग इनटू द कॉन्ट्रैक्ट है, तो उसके बेसिस पे लॉ जो है वो प्रोटेक्ट करता है infants ko, so that they are not misguided, their undue advantage cannot be taken by the others. On the other hand, agar kahi situation mein minor is misusing his minority, minor can always plead his minority, but in certain circumstances the court of law has the right to grant relief to the other parties, and section 33 of specific relief act is one of the particular exception where even minor pleads his minority. As per the Indian Contract Act, the agreement with minor is void. Still, the other party can get the advantage or benefit, or the particular contract can be valid in certain situation, or the doctrine of restitution is applicable in those circumstances. Right? Now, in continuation with validity, we move further where we say that many beneficial agreements are valid contracts in case of minor. Beneficial contracts just a second. Beneficial contracts are valid. Right? So what does it mean? On the first go, we are saying agreement with minor are void, not enforceable by law. On second situation, we are talking about the doctrine of restitution, which is not applicable, but with an exception of section 33 of Specific Relief Act. Right? Third situation we are talking about, beneficial contracts are valid. It means that we are talking about the different aspects in case of the minors, different situation. So when we talk about the beneficial contracts are valid contract, so again here we are talking about the protection given to the minors. ठीक है, तो अगर कोई भी कॉन्ट्रैक्ट माइनर के बेनिफिट के लिए है, तो द अदर पर्सन हैज नो राइट टू सेट इट असाइड ऑन द बेसिस कि वो माइनर है, सो आई एम नॉट गोइंग टू परफॉर्म द कॉन्ट्रैक्ट. Are you getting the point that the law is having its protection clock towards the minor? So अगर वो contract suppose उस केस में minor ने loan लिया था, now in this case minor has given loan to the other party. And the other party has, mortgaged certain security or property or certain things are being given to the minor. In case may, this is going to be valid and enforceable. Why? Because it has been for the benefit of the minor. So this particular situation or case law has been given in the case of Raghav Rear versus.
मैम इसमें एक्सेप्शंस नहीं है कि किसी
No,
केस में अगर वो रिवोक करना चाहे तो इट इज़ पॉसिबल अगर वो उसके बेनिफिट के लिए भी था तो?
नहीं, बिकॉज द अदर पार्टी इज नॉट अलाउड. लॉ का जो रूल है वो कहता है कि वी आर गोइंग टू प्रोटेक्ट द इंटरेस्ट ऑफ द माइनर, क्योंकि लॉ द मेजर पर्पस इज दैट द माइनर्स इंटरेस्ट आर नॉट affected and minors are protected. So in this case the other person is not allowed to take undue advantage of the minor from both the sides. Minor can take plead minority, minor can take in certain circumstances undue advantage, बट द अदर पर्सन इज नॉट अलाउड, बिकॉज एक बार अगर कॉन्ट्रैक्ट बन गया तो वो एनफोर्सेबल बाय लॉ हो जाएगा, लीगल ऑब्लिगेशन हो जाएगी. तो अगर द अदर पार्टी इज टेकिंग अ चॉइस टू एस्केप, माइनर हैव ऑलवेज राइट टू गो टू कोर्ट ऑफ लॉ टू गेट इट एनफोर्स्ड.
ओके मैम.
Right? So in this case, the purpose is that the beneficial contracts are valid. So in this particular case, in Raghava Acharya versus Srinivasa, what happened in this particular case? कि minor ने loan दिया, minor has given loan to the other party, and the other party has mortgaged the or given the security to the minor. तो उस केस में वो सिक्योरिटी और मॉर्गेज भी वैलिड होगी, एंड द अदर पार्टी इज बाउंड टू रिटर्न द मनी टू माइनर एज वेल. तो रिवर्स हो गया ना मोहिरी बीबी वर्सेस धर्मदास घोष केस का फर्स्ट पॉइंट का. दैट्स व्हाई आई स्टार्टेड विद द फर्स्ट पॉइंट कि हम इनिशियली कहते हैं कि एट इट्स फेस अग्रीमेंट विद द माइनर are void, it's not enforceable by law, does not give any rise to the legal obligation. And in continuation we say doctrine of restitution भी एप्लीकेबल नहीं है, माइनर बाउंड नहीं है रिटर्न करने का. लेकिन अगर वो कॉन्ट्रैक्ट माइनर के बेनिफिट के लिए है और माइनर की इंटरेस्ट को प्रोटेक्ट करता है तो वो आपका वैलिड होगा, एंड द अदर पार्टी इज बाउंड टू परफॉर्म. तो उसमें डॉक्ट्रिन ऑफ रेस्टिट्यूशन भी एप्लीकेबल होगा. अगर उसने कोई माइनर ने सपोज माइनर हैज सोल्ड हिज लैंड टू समवन and he has someone has sold land. One second, uh, we are talking about doctrine of restitution. Yes, so in case of doctrine of restitution, minor has sold land to someone and have got the money. So अगर वो set aside होता है तो minor उसको रिटर्न करने के लिए मनी देने के लिए बाउंड नहीं है. बट अगर उसने माइनर को सेंड किया है और कोई एडवांस मनी मिली है तो दैट पर्सन इज बाउंड टू रिटर्न दैट एडवांस मनी एज वेल. So in that case, both the things are going to work in favor of the minor, right? So in continuation, we have certain other situations with respect to the for the benefit of the minor. For example, the training or for his guidance, educations, etc. These points we are going to cover in the next class because I think you are having the next lecture lined up. So let me stop lecture
एक्सक्यूज
now.
मैम.
हाँ जी बेटा.
मैम जैसे हमने ये डिस्कस किए कि डॉक्ट्राइन के हिसाब से मैम बेनिफिट जो है वो ऑलवेज विल लाई इन द हैंड ऑफ माइनर. तो
Yes.
मैम ऐसे नहीं हो सकता कि मैम मतलब माइनर्स फिर इस चीज़ का फ़ायदा उठाते हैं, लाइक
Yes.
पहले कॉन्ट्रैक्ट कर लिया एंड देन उसके बाद मना कर दिया
Yes,
उसको
yes.
फॉलो
That's
करने के
why
लिए.
that's why we talk about the specific relief act. We talk about the law of court discretion in those circumstances,
ओके.
right?